It's with lots of pleasure and only a little trepidation that I welcome everyone back to the new year, the new term, and of course part 2 of ethical lawyering and a global community. And we are very much looking forward to this section of the course, to getting back into the lively discussions we left off in September, hearing more about your own thoughts and journeys in law school over the other courses you took in the fall, and of course exploring some really important, interesting issues, compelling top-of-mind topics given the headlines in the fall, and of course getting you rolling up your own sleeves in the paper and in the case study project. You'll hear more about all of that in addition to the various readings and themes for each day when we separate into our sections after this plenary session. But the plenary session is an absolutely perfect way to kick off part 2. And I'll introduce Ian Kyer, who's here to take us through a little bit of a different lens on professionalism, ethics, and legal education, and one that is rooted in the question that we haven't really explored well enough, it seems to me, after week 1 of this course, and that's how did we get here? Where did we come from? How did the profession, legal education, take shape in at least this jurisdiction? But again, no jurisdiction is in a vacuum, and so picking up on trends and themes in the US, in the UK, elsewhere in the world is an important comparative insight or lens on the topics we're exploring. And all of it has a really important and really intriguing history, and some of the stories that ought to be told about that history you're going to hear through the eyes of some of the individuals who were either a product of their times or helped shape their times, I think it's fair to say. And we hope that that discussion and the sense of a historically rooted vision of legal professionalism is something that carries forward during this second part of the course. So Ian is the perfect interlocutor for this project, and many of you will know him from the really enjoyable and landmark study he co-authored, The Fiercest Debate, which tells the story not just of Osgoode, but of legal education in Ontario, in the emergence of the University of Toronto's law school and the other law schools in the province, and told through the story of Caesar Wright, who is really one of the most remarkable figures in the history of legal education, and someone, of course, who played a huge role in this law school. So how did Ian come to be the interlocutor of legal education's history? He'll tell you a little bit more about that, but let me tell you a word or two about him. And he brings not only a law degree, but a doctorate and was it in history? I hope it was in history. It's the kind of thing you should check before launching into someone's background. But it was just as he received his doctorate, I think just before he was receiving his call, that he was asked to join what was then Fasken and Calvin, now Fasken Martineau or simply Faskens, where he spent the bulk of his career following the trajectory in the growth of IT law and all of the different permutations that the world of technology has created for law. And he spent, and I was just double checking this so I know I've got it right, 33 years at Faskens before his retirement from the firm in 2013. And we were commenting on how common an experience that would have been for those graduating in his year, and how rare it's going to be for any of you to spend your entire career more or less at a single firm. He has gone on from that long career at Faskens to now a practice in-house in, again, information technology law at RPM Technologies. And I think it's again, testament that he's well known to many of us for his work in legal history, legal education, and so forth, but he is also one of the country's finest lawyers in the field he specialized in, and has been recognized in a variety of the Lexis top lawyers, Lexperts top lists, and so forth, and lectures and practices in areas that really have begun with computers and now include online gaming, all sorts of important and scary new worlds. His two main books in history, that one of which I've mentioned, The Fiercest Debate, Cecil A. Wright, The Benchers and Legal Education in Ontario. You'll see the first introductory section in your readings for today. His other more recent book, Lawyers, Families, and Businesses, The Shaping of a Bay Street Law Firm, Fasken's from 1863 to 1963, was published by the Osgoode Society in 2013. And again, there's a series of articles and other publications to his credit over the years of his busy practice. So we're really delighted to welcome you here, Ian. We're going to have a chance to hear the stories that you're going to tell, and then there'll be some time afterwards for questions, and we hope this will lead into lively discussions in the sections to come. Please join me this brisk morning in giving a warm welcome to Ian Kyer.
Thank you, Dean. When I was in first year law, I didn't want to be here. I had done a PhD in medieval ecclesiastical history, and I discovered, as my father had warned me years before, that nobody would hire me with that sort of a background. It was my wife that convinced me to go to law school. So I was sitting in class wishing I was actually teaching in the history department, which I was doing part-time at the time, much to the chagrin of the dean, who told me that was contrary to the rules. Anyway, what really got me involved in law, which, by the way, I love, and I have enjoyed practicing law immensely. So my wife really deserves a lot of credit for getting me into a practice which I've truly enjoyed. But what really got me into this was now Mr. Justice Robert Sharp. I thought of him as Professor Bob Sharp. He was teaching a class like this in first year, where his job was to give us some background on legal history. And I don't know if you know Justice Sharp. He's a fine gentleman and has become quite a legal scholar. But at the time, he said to the class, I don't know very much about legal history at all. There are probably people in the audience that know more about legal history than I do. And if any of you would like to teach this part of the course, just let me know. I put up my hand. And he and I then taught the legal history section during the 3 years that I was at law school. It was fun. I loved it. It gave me an opportunity to blend my history interests with my legal studies. And I got bitten by the bug, and I have been studying legal history ever since. And there's a lot of great stories, and I want to share some of them with you. The theme of my presentation today it's more a question. How ought we to train lawyers? And it's interesting that the answer to that question has differed dramatically over the years. The early years, and we're going to start in 1856 in a moment, but the early years all took it for granted that the way to learn to be a lawyer was to work with a lawyer. You were an apprentice. So it was thought to be enough to basically learn how to prepare documents, where to file them, how to fill out forms and so on by working with someone doing that, as they refer to it as an articled clerk. We would say articling today. So if you think of the 5 W's, who, where, what, when, and why, the emphasis was all on the first 4. Who ought to prepare documents and who has legal rights, where ought documents to be filed, what ought they to say, when should they be done, all of the how-to things, the practical aspects of practice. Very little spent on why. In fact, I think it's probably safe to say no time spent on why. Why do we have laws? Why do they take the form they do? What interests are they intended to protect? What behavior are they intended to discourage? None of that was thought to be important to practicing. Practicing was basically a trade, and you learned it by working with others who were specialists in that trade. Over time, as we will see, another view developed. A view that we have now all sort of taken for granted, that the proper way to train people is like you go to a university, you do an undergraduate degree, you then go on and do your quotes graduate work in law. So this came to be seen as the debate between the law school and the office being where you learn practical things. And you will hear people, as we go through and look at this, talking about the office and the law school. Ontario drew its early ideas, only naturally, from England, because it was an English colony. And in England, the pupillage system, the apprenticeship system, was the way that one learned how to be a lawyer, and so in Ontario, that was adopted. Over time, more and more we drew ideas from the United States, where the Harvard Law School model came to be seen as the way to train lawyers. But Ontario, as you will discover, never abandoned the idea that learning about how to do things through an apprenticeship was an important aspect of legal education. So I want to look at the last 150 years or so of legal education through the eyes of 6 lawyers. Now I'm going to apologize for the fact that all of them, except one, who I wish had been a member of Fasken's but wasn't, all of them that I'm going to look at are members of Fasken's. And that's in part because I've just written the history of the firm, and these are people that I've come to know and like, and they tell the story very well. So we're going to start with Edward Marian Chadwick. In 1857, Marian, as he was called, began his legal studies in Guelph, where he became an article clerk. He was 16 years old. He had done high school, as matriculated, as they said then, and he was about to become a lawyer. So the Law Society provided him with a little guidance. They said, a lawyer needs to be conversant with the knowledge of the profession in all its branches, the practice as well as the principles, with equity as well as common law, the rules of pleading and those of evidence. In short, you are to place yourself in a position to be able, without extrinsic aid, to advise a client on any matter in which he may require advice, and to carry through a suit in all its stages. Okay, sounds all great. That's the goal. How do I get to there? Well, teach yourself. There was no formal instruction. He just became an article clerk in a law office and worked with Messrs. Lemon and Peterson in Guelph, where he discovered that law was a lot of menial tasks, at least as he saw it. He was filing documents, he was doing searches of titles, and mostly he was writing. Penmanship was considered to be the most important attribute of the law student, to be able to write clearly. And that's, you got to imagine a world where all of the documents that he's going to be dealing with the exception of a few printed texts, are handwritten. And as a historian who goes through and reads diaries and letters and so on, good penmanship is something you do really come to appreciate, because people who scrawl are very hard to understand. So one of the important tasks, if you were a law student and you're starting in your career, one of the important tasks you would have is learn to engross documents. Documents would be prepared by the lawyers in some sort of shorthand, and then you would have to write it out in full, in beautiful penmanship, so it could be read easily by the courts or by the other members of the, if you were doing a transaction, whatever. So a lot of attention was paid to penmanship, very important aspect of training. And as it happened, Chadwick was an exceptionally good penman. He was also an artist, as you can see from this is from his diary. Monday, 14th, some month, showed up at Lemon and Peterson and got told to go off and help with the feeding of the poor. So there he is with this beautiful picture. This is the diary that he prepared when he started his law studies. A brief but accurate record or journal of the deeds, misdeeds, or adventures of Edward Marian Chadwick, commenced on the first day of January in the year of our Lord, 1861. Thank goodness, by the way, for his diary. It's one of the reasons why I was able to tell the story of Fasken's in the early years. Anyway, his youthful enthusiasm for law waned when he discovered what was involved in being a law student. He really wanted to understand more about law. And as it happened, he had an opportunity because they had just started in 1858. The Law Society had appointed 2 permanent lecturers, S.H. Strong for equity and J.T. Anderson for law, and they began to offer lectures at Osgoode Hall, which looked like that in the old days. So the only fly in the ointment was that you had to go to Toronto to attend the lectures. It was regarded by many people in the province as an inappropriate expropriation of legal talent by Toronto because Ottawa and London and various places, all of whom could, of course, train lawyers through the apprenticeship program, did not have the lectures. And so many went to Toronto to attend these voluntary lectures, and they were voluntary. They were just intended to prepare you for your exams, no marking on the lectures as such. So the thought was that this was the way that Toronto was attracting all of this talent. People would go to law school there and then would stay there and practice in Toronto. Many people in the province complained that it was inappropriate that that happened. So in February 1862, when he had about a year left in his articles, Chadwick went off to Toronto. And he attended the lectures and he finished his lectures. On February the 20th, 1862, he wrote in his diary, "Articles expired, I am released from bondage." 5 exclamation marks. He clearly was happy to be out. But he still had to write his exams. He had 2 sets of exams. One, these were both oral and written exams. One to be certified as a solicitor, and then a year later, another exam to be called to the bar as a barrister. So after he passed the first set of exams, he and his roommate, Calvin Brown, began to study for the really hard exams to be called as a barrister. And they prepared very detailed materials. Remember, they're teaching themselves largely at this point. So they gathered together all this material, and they thought, wow, we've got a lot of really good study notes. So being entrepreneurial, they published them. This was the first textbook that was prepared for Osgoode Hall. Osgoode Hall examination questions given at the examinations for call, with and without honors, and for certificate of fitness with concise answers, and the Student's Guide, a collection of directions and forms for the use of students at law and articled clerks. It was a bestseller amongst the few legal students that there were at the time, but Carswell published it. So he then, of course, had to go off and find a job, as he said, to sell himself to diverse legal practitioners. But he was unable to do so. He ended up spending a year with the firm that he had articled with, without pay, just to get experience. Then he got fortunate, and he, in fact, ended up meeting a young lady. Her brother happened to be also getting ready to practice law, and the 2 of them formed a law firm in February 1863 called Beatty and Chadwick, which we know today as Fasken Martineau Dumoulin LLP. So that was Mr. Chadwick's experience with law, very much in the English tradition, a little bit of lecturing, but mostly self-study. Let's go on a few years. Go into the 1870s and look at Thomas Gibbs Blackstock. Thomas Gibbs Blackstock is one of my favorite lawyers in the history of the Faskens law firm for a whole host of reasons. Interesting man. He was the son of a very influential but poor Methodist minister. So his father was an itinerant preacher. He would go around on horseback from community to community in the Methodist teaching, or preaching, excuse me, and often paid in chickens and, whatever, eggs. Didn't have a lot of money. At age 16, Tom left home because he was a burden, he thought, on his family. He went to live with his in-laws. Now, as it happened, his mother was from a well-to-do family, the Gibbs family from Oshawa. And so Tom was looked after by the Gibbs. But Tom refused to have the Gibbs people pay for his education because he just thought that it was inappropriate. He didn't want to be beholden to them. So he insisted that he pay his own way. And his father had told him that there was nothing better than a university education. So he wanted to go to university. Now, this was an optional way of preparing for law at the time. You had a choice. You could do as Chadwick had done and spend 5 years articling without going to university, right out of high school. Or you could go to university, get an undergraduate degree, and then all you had to do was spend 3 years of articling. Now, if you add it up, you discover that that means you're spending an extra year if you go to university, right? So 5 the first way through, 6 the second way through, but you're better educated. But what was happening is that the well-to-do people were going to university, and the people who had to pay their own way were not. Because 3 years of tuition, room and board, all of this, the things that all of us know only too well, was a real challenge for people who didn't have money. Now, as I say, Tom could have had his in-laws pay for the university, but he insisted that that not be the case. But he was a very smart man. He won a scholarship at Upper Canada College and then another scholarship at the University of Toronto. So that certainly helped, but it didn't pay for all. We were very fortunate. Tom, because he was living away from home, wrote these letters to his parents. And so we have all of these things in which he's debating, do I, go to university, do I not? At one point, he said he was going to go to university, and then he wrote to his father, and he said, Dear Papa, in response to one of the numerous advertisements appearing in the Globe for a law student, I applied to Snelling and Clark. I waited upon them today, was asked to do some writing. See, how do you tell whether you're a good law student? Write. And of course, I did my worst, but they did offer me $50 a year, though I could have gotten more had I pressed, but I preferred to be at my ease. And lastly, the greatest consideration is that I expect 5 years in learning the profession by which I expect to obtain my bread and butter, instead of 3 years hotting between Osgoode Hall and an office will be better. And what could be better than learning from an ably gifted and so willing Mr. Clark? Well, his father said, no, hold on a second here. Don't give up your dream. He said, I want you to go to university. Tom then went, he talked to his teachers, and they said, yes, university education will be better. Although it's funny, Mr. Lauder, his professor at the University of Toronto, said, it seems to me upon the whole that if you have sufficient means, it's better to take the university course. Though university men do not do as well as others because they're not sufficiently acquainted with business. But you might get on well if you go for 3 years but into an office with a large connection, such as Blake's. So Tom did decide that he would continue with the university, and he came up with a novel way of paying for university. He went buffalo hunting. how many lawyers started their career as a buffalo hunter? I suspect that Tom may be unique in that regard. He didn't initially intend to be a buffalo hunter. He actually thought he would sell Bibles. He went out to Topeka, Kansas with a stack of Bibles and discovered that, lo and behold, nobody wanted to buy them. So he did say Topeka, Kansas was the most eastern-like of western cities, the most church-going, but notwithstanding that, he couldn't get a job, or he couldn't sell his Bibles. So he went on to Dodge City, and there he found he had saleable skills, because he knew how to ride, having gone with his father, riding about to the various churches. And he also was an award-winning marksman with the Queen's Own Rifles. And so he put his skills to use and he hunted buffalo. Now, for those of you who are environmentally conscious, I want to assure you that, in fact, Thomas Gibbs Blackstock was an environmentalist. It's true he did participate in the slaughter of the buffalo, but he felt guilty about it. And a year later, when he was a successful lawyer, he donated a herd of buffalo to the Canadian government, which is the basis for the Wood Buffalo National Park herd. And I was reading a history of parks in Canada, and they say that that donation by Thomas Gibbs Blackstock changed conservation in Canada significantly. So we can forgive him for his buffalo hunting. But he did come back with a lot of buffalo skins, and he paid for his education. He resumed his studies in 1874, briefly articled with William Mullock, one of the great Toronto barristers. But he didn't like working with Mullock because Mullock made him work too hard, didn't leave him enough time to do his studies. Because remember, the whole purpose of all of this is to pass the exams at the end. So he joined another smaller firm, but much to his chagrin, they did not offer him a position when he was called to the bar. He briefly practiced on his own, and then, much to his family's chagrin, he went into partnership with a drinker and a smoker. Oh, my goodness. So they had to do something about that. So they took him out of that firm, and they got him, and they put him into the Gooderham-Warts family firm, because the Gibbs were related to the Gooderhams, and that firm was Beattie and Chadwick. And so Tom joined that firm. The firm eventually became called Beattie Blackstock. One of the people that Reeve met when he was articling at Mullock was William Albert Reeve, who you all should know because he was the first principal of Osgoode Hall Law School. Now, when Tom met him, he was not that. He was practicing as a sole practitioner in Napanee, Ontario. Reeve, though, was very well educated. Not only did he have an undergraduate degree, but he had a master's degree as well. The problem with Reeve, unfortunately, is that he wasn't good with clients, either getting them or keeping them. Two important skills you'll discover when you're out practicing. He was considered to be too retiring a disposition. The reality is he was too academic for the practice. He practiced. Tom Blackstock brought him into the Fasken's firm, and he practiced unsuccessfully there for a few years. And then Mr. Beattie tried to get him a job as a judge, which is why he's writing to Sir John A. Macdonald here. Thought he was quite suited to be a judge. He had very good judgment. He just, unfortunately, wasn't good with people. So he didn't get the judgeship, but he got to be the first dean of Osgoode Hall Law School, the first full-time teacher of law in the province of Ontario. And being the good academic that he was, what did he do when he became dean, or principal, excuse me? He went down to the States, and he went to Harvard and Cornell, various university law schools, and studied what they were doing down there, and brought a lot of their ideas back to Ontario. Now, in the debate that I mentioned about the practical versus, the theoretical and the sort of the more academic grounding for law, the 4 W's versus the Y, he was trying to find a way, in a sense, to blend the two together. He gave his opening talk at the law school and said, rightly considered, there is no conflict between the educational functions of the office and those of the school. Both are necessary, each is the complement of the other. And in a sense, if you were to say what is the theme of legal education in Ontario, I think that, in a sense, is the theme, that you need both. Academic training is, I think today, especially with the world as complex as it is essential. But practical training is also important. And so he built a system that to try to take advantage of both. And they came up with a law school arrangement where classes now became compulsory, but it was combined with practicing as an articled clerk. So you'd start your school day in the morning with lectures, 8 till 10, and then you'd go off and practice as an articled clerk for the day, and then come back from 4 till 6 to get 2 more. Later on, Bora Laskin would say, we got students before they woke up in the morning and after they fell asleep at night. But that was the system that was created, and that system continued for some long period of time. Regrettably, Reeve didn't get to see much of it. He died at age 52 in 1894. But one of the things that he did get to see was this woman. If there's a hero, in a sense, in our story, certainly Clara Hughes, Clara Brett Martin, excuse me, has to be one of the ones we consider for that role. I see, looking out here, all of the women in the audience. Of course, up until Clara, there were no women in law school. It was exclusively male. It was thought that women were like Reeve, of too retiring a disposition, too gentle, not sufficiently strong to be good advocates. Well, Clara proved that wrong, for sure. She turned out to be a very, very good advocate for her own cause and the cause of women in law school generally. So, her first problem, unlike, Tom Gibbs Blackstock, who debated about, do I go to university and so on. She had already gone to university. She had an undergraduate degree when she applied to the law school in May 1891. And she had the money to pay for this. But the benchers nevertheless rejected her application on the basis that she was not a person qualified to become a lawyer. The words in the Law Society Act were, that the Law Society is open to persons seeking to enter the profession. But clearly persons did not mean women. So she didn't take this lying down. She put together a coalition of prominent people in the community who supported her, the most prominent of which was Premier Mowat, the Premier of the province of Ontario. So to ensure there could be no doubt, Mowat's government passed a bill in the Ontario legislature that permitted the Law Society to consider the admission of women as solicitors. So in September 1892, they did consider the admission of women, and they decided no, they don't belong. So Premier Mowat was not pleased. As a former Attorney General, he was an ex officio bencher of the Law Society. So he personally attended convocation, as was his right, in December, and he made a motion that women be admitted to the profession. And even though this was the premier of the province of Ontario, the vote was close, 12 to 11, but Clara got in. She articled with Mullock, as Mullock Miller, as the firm then was called. To just let you know how small the profession was, the Miller that was Mullock Miller was Nicholas Miller, whose departure from the Beatty firm had opened up the place for Reeve to join the firm. It was a small community in those days. So in 1896, Clara convinced the Ontario legislature to permit her to be called to the bar as well. Initially, they were allowed to be only solicitors, but then in 1896, the province then said, you could also be called to the bar. And she became the first woman called to the bar in the British Empire. But she didn't find a place at Beatty Blackstock or any of the large downtown firms. That would take 60 years before they broke into the large law firms. Now, one of the people that Clara was in class with was this gentleman. Whoops. Oh, sorry, great line. If it were not that I set out to open the way to the bar for others of my sex, I would have given up the effort long ago. That's what she said on being called to the bar. It's not an easy road for her. By the way, she became a family lawyer, which was regarded as the women's role in law for a number of years. Okay, one of the people that she would have met at law school is this gentleman, RSRobertson, Robert Spellman Robertson, who, like Chadwick, went into law right out of high school. Now, it wasn't because his family didn't favor education. In fact, it was the opposite. He was the odd man out. He had 3 brothers. His oldest brother, John Charles Robertson, was the gold medalist at the University of Toronto, did graduate work at Johns Hopkins, became a noted classical scholar, and in fact became the Dean of Faculty of Arts at the University of Toronto. So certainly somebody who knew academics well. Second oldest brother, Alexander Morton Robertson, also a university graduate, also taught at university in modern languages and mathematics. Interesting combination. William, his youngest brother, went to university and became the editor of the Goderich Signal, the newspaper in Goderich where they grew up. So R.S. Robertson not going to university was something unusual. He was clearly very bright. It was just that he didn't think it was the right way to learn how to be a lawyer. He attended elementary school and high school in Goderich, and then he went, became an article clerk with J.T. Garrow, who would later be appointed to the bench. So he was sworn in as a barrister just before Clara Martin. He became, in fact, one of Ontario's best litigators, extremely good. In 1930, when a vacancy occurred in the ranks of the benchers, Robertson was chosen by convocation to fill it. And that was the beginning of him being elected subsequently to be a bencher. When he became a bencher, he was appointed to the Legal Education Committee. And they were faced with a question of, ought the law school to become a full-time university school? Dean John Falconbridge and his teaching staff at Osgoode Hall were starting to push for this. Now, initially, they didn't ask for it to be a full-time university school. They wanted it to be a full-time law school, but the university part was what they would have liked, but they didn't initially ask for it. Now, one of the people who was pushing for this was this fellow, Cecil Augustus Wright. Now, if you have a name Cecil Augustus, it doesn't take long before your friends begin to call you Caesar Augustus or Caesar, and that's the name that he came to be known by. Now, he looks like somebody who would say, I favor an academic approach to law, don't you think? So he was a very bright guy from London, Ontario, came to the law school, won the gold medal. The dean wanted him to go to Harvard for graduate work, and he did. And he went off and did a doctorate in law at Harvard. Then he came back and he joined the legal the staff, at Osgoode Hall Law School. One of the people that he got to know, a fellow teacher at the school, was Sidney Smith. Any of you who have went to U of T or visited U of T on St. George will know Sidney Smith Hall. It's an awful building. Sidney Smith is actually a great person. It's a sad thing to me that this very interesting man gets this terrible building named after him. Anyway, Sidney Smith and Caesar Wright became very close friends, and that became an alliance that would change legal education. They went on to quite different careers. Smith went off and became the dean at Dalhousie Law School, and then the president of the University of Manitoba. And then in 1945 became the president of the University of Toronto. Meanwhile, Caesar Wright had spent his career trying to convince the benchers to change legal education. His time at Harvard had convinced him that university education was the proper way to train law students. And it became his life's goal to change the way that legal education was carried out. And it turned out Sidney Smith would be a very valuable ally once he became the president of the University of Toronto. Smith was also very well connected politically. He would eventually become a cabinet minister in the Diefenbaker conservative government. But his conservative ties, political ties, would also prove very important in changing legal education. Now, initially, going back to 1930, Wright, the first person, or one of the people that Wright had to convince that legal education needed to change was R.S. Robertson. Now, you got to remember, R.S. Robertson is a product of the old system. He has done exceptionally well. He does not believe that you need a university education. His brothers went off and did all of that university study, but he is dominating, the legal profession without any of that sort of training. So he knows that it's not essential that you have this sort of training. So he was not enamored of Wright's ideas. This is what he said in the 1935 report that was written on legal education. If you gave students the sort of education that Wright wanted, the university education, they would be far beyond the stage of learning to do accurately and carefully the innumerable small things that fall to the lot of the young lawyer in his practice. So, remember, going back to our W's, the emphasis is on the practice. Are they going to know how to file documents and, when to do things and how to fill out forms and all of these sorts of things, which had traditionally been the role of the law student and the young lawyer. As opposed to what Wright wanted to encourage people to do is to think about the law, to think about why things are done the way they're doing. How can you have law reform if we don't ever stop and think about why the law takes the shape it does? So that's why Wright wanted an honest-to-God law school, as he used to call it, as opposed to this quasi-law school that Osgoode Hall was, where you get people before they woke up in the morning and after they fell asleep at night. So, summer of 1945, now we've gone 10 years later, Wright is now working with his friend who's now the president of the University of Toronto. What better ally to have in the fight to turn law into a university discipline than to have the president of the university as a former teacher at Osgoode Hall and your longtime friend. It's funny, when Wright learned that Smith was going to become the president of the University of Toronto, he wrote this amazing telegram. Allah be praised, lassie come home, never happier in my life. It was an emotional outpouring. So, he had his friend. Who do they have to convince, or who do they want to get on side? R.S. Robertson. Now, R.S. Robertson is the Chief Justice of the province of Ontario. A very powerful figure, a very influential person, somebody whose opinion would matter to the benchers. A former bencher, person who wrote the report of 1935 that said that, things were good as they were. If we can get him on side, then surely we can win the battle. So, Wright goes off to see him in the summer at his cottage at Magnetawan. And they're sitting by the lake talking about legal education. I can imagine more exciting things to talk about, but that's what they were talking about. And it was exciting to them because it mattered to their lives. One, because he was the teacher of the students, and the other, because he saw the results of what was coming out of the law schools in front of him on a daily basis. So, Sidney Smith was not there. So right after the meeting, wrote to Sidney Smith telling him what Robertson said. He thinks that legal education in Ontario is lousy. Something must be done. He's been moving to the idea that the best thing is to give a lawyer a good education and he will know how to go about his practical work. I have a feeling he likes me. 4 exclamation. Oh, 1, 2, 5. Oh, 5. Wow. He also was very excited. So they thought, this is it. We've got the Chief Justice of Ontario on our side. How can we lose? Well, the benchers, unfortunately, they may have admired Robertson's career and so on, but they thought it stood for the fact that the current system was quite good. It had produced Robertson. Why do we need to change? So they would not do this. Wright and Smith got the province, the premier of the province of Ontario on side to encourage the benchers of the Law Society to rethink the issue, just as Clara Martin had gotten Mowat on side. This time, the result wasn't as close, and it was a loss. What the Law Society did agree to do was to have a study, and they commissioned the study. And in 1948, Caesar Wright became dean of the school by virtue of seniority, I suspect. I mean, he was an excellent teacher, but I don't think at that point in time the benchers particularly liked him. He'd become a thorn in their sides. He was always going off. He loved to quote these things he would say to the Globe or the Star and so on. You know, if medicine were like law, we'd be in the age of the leeches still. So anyway, they didn't particularly like Wright. But they said they would study it, and they did study it, and they produced a report that came out in March 1949. Ironically, on the day that I was born. I thought to myself when I was doing this study, I must have been intended to write this history, right? The report that triggered all of this came out on the day I was born. I didn't know. I was paying attention to other things. Anyway, so they were so upset with Wright that when they issued the report, they gave it to the newspapers, and they did not tell the dean of the law school about what the final report said. He read about it in the newspaper, the Globe and Mail. Called together his faculty, Stanley Edwards, John Willis, Boral Askin, Walter Williston, and they all got together and they decided to resign en masse. They said, we're not going to give the benchers any choice. We're going to just quit. We're going to go off to U of T and found a school, and they're going to have to acknowledge us because, after all, they can't carry on without us. When I was doing this research, John Willis wrote to me and said, had we thought that the benchers would actually accept our resignations, I, for one, would not have put it in. But they didn't think they would accept it, but the benchers did. They said, no, we're happy with the way things are. So they accepted this, and off Willis and Laskin and Caesar Wright went. Stanley Edwards and Walter Williston went into private practice, Stanley at firm then known as Fraser and Beattie, and Walter Williston at Fasken's. So we now have a school being set up at U of T, has no students, but it has an excellent faculty, and we have a lot of students at Osgoode Hall, no teachers, no full-time teachers. They had members of the profession who were still teaching. But the benchers just went out and hired new faculty, wanted to continue as they had been doing, but they had to reach a compromise. They ended up going with a 2-year full-time program, followed by 2 years of articling. They were good enough to say that the U of T graduates, who were after all taught by the faculty that they themselves had had in place before, they can hardly say they weren't qualified, those people were admitted, they could then do the 2 years of articling as well. So again, we go back to the 5, the extra year, if you want a university education. So if you went to U of T, you did 3-year undergrad, 3 years at the law school, and 2 years of articling. If you went to Osgoode, you could still go directly out of high school, but you would have to go at least 3 years at the law school and 2 years. So from 1949 to 1957, that's the way it continued, with the 2 schools and this discrepancy in the treatment of the groups. Now, one of the people who worked behind the scenes to bring the benchers around was Walter Williston. Walter is an amazing man in a lot of respects, both good and bad. He did not join Wright and Laskin and Willis at U of T. He returned to his private practice. He had been, he was called to the bar in 1944. He had been practicing at Fasken's for a few years before he became a full-time teacher in 1948. He only spent 1 year full-time teaching at Osgoode Hall. Caesar Wright appointed him. When he became dean, Caesar was entitled to appoint 2 people, and one of them was Walter Williston. And they became lifelong friends and allies. But Walter felt more at home in practice than in the classroom. So after his eventful year, he didn't go off to continue. He went back into private practice. But he worked behind the scenes. He got elected as a bencher, and he worked to try to convince the benchers that their system was silly and that they should go with full-time university schools and open it up, not just to U of T, but to universities generally. It took till 1957 for that to happen. And money ultimately became the most important factor. It just got too expensive for the profession. Remember, this was a privately funded school in those days, Osgoode Hall. Whereas universities were publicly funded. So in 1957, the benchers finally decided that it was costing too much to do this. They opened it up, and we got the system much as we know it today. And one of the people who became important in achieving that goal was Walter Williston. And I want to tell you just a little bit about Walter, then I got to wrap up because I do want to have time for questions. Walter was a more modern person, in a sense, than many of the people we have looked at in the study so far. For those of you who know anything about civil procedure, you'll know that there is a book called Williston and Rolls on Court Forms. And Walter taught civil procedure at what became the bar admission course after this compromise in 1957. The compromise was we have a 3-year university LLB program, D now, or JD now, and that's followed by the 1 year of articling, and then they had a 6-month bar admission course. At that bar admission course, Walter taught civil procedure. The Rolls in Williston and Rolls was Ron Rolls, and they were the odd couple. I don't know if any of you know that Neil Simon play, The Odd Couple, but became a television program many years ago. In the play, we have the sloppy person and the fastidious person. Well, that was Walter and Ron Rolls. Ron was exceptionally well organized, spoke with great precision, great attention to proper grammar, enunciation, dressed impeccably. And Walter was sloppy, not in thinking, but in dress. But they got along very well together. They worked very well. But they were different in one other way, and that is Walter was heterosexual. He loved women, much to problems that he created. He ended up marrying 4 of them. And Ron Rolls was gay at a time when being gay was not accepted. But Walter knew that Ron was gay, and he welcomed him, as he did with others. Walter was a very open person, much more inclusive. That's why I say more modern than many before him. And that may be in part because Walter had an unusual background. He was born in China. His father was an Anglican missionary. His mother was Jewish. He became an iconoclast. He loved fighting on behalf of the underdog, and became exceptionally good at it. If it wasn't for the fact that he was also a drunkard, he would have had an even more brilliant career. Anyway, fascinating man, very interesting. Now, the dean mentioned this, but I would encourage you, if you want to learn more about this, for those of you who haven't fallen asleep during this presentation, The Fiercest Debate, I think of it as my therapy. It was the book I wrote to feel good about being in law, the history of legal education, and the latest book, Lawyers, Families, and Businesses, which is about the Fasken's firm, but it's more about Toronto society and the practice of law over a century and a half and how it changed. It focuses obviously on Fasken's, but it's not a narrow focus. I try to tell a broader story. Anyway, so open for questions.
First, let's thank first let me just say, for those who joined us in October, on October 7th, as you'll have read in the introductory section and heard a little bit when the story of Reeve was being told, in 1889, there was an inaugural address to this fourth attempt at getting a law school at Osgoode firmly established. This one took, and so we take that date, October 7th, 1889, as really the birth point of this law school. And so in October of 2014, on the 7th, I read some passages from that inaugural address by Reeve. We marked the 125th, and we've been doing a series of events over the academic year to take note of the milestone. But of course, it was a completely disembodied reference. Who is this Reeve? Where did he come from? Where were his ideas formed? And I think it is amazing to connect some of the dots of the times that shaped some of the individuals and the individuals that shaped some of their times. And it is a story of that push and pull, including some of the outsiders who either studied outside, grew up outside the community, coming in typically more as the reformers, and this ongoing pushback from an establishment that quite liked the position of privilege and power that it enjoyed. And in fact, these are themes, every one of which Ian's touched on, that we wrestle with today, whether the themes of reform, practice versus academic training in law, some of the backstories of outsiders, insiders, money and privilege and power shaping regulatory aspects of the profession, and the story of who gets access to education and so forth. So a great history to tell, an important one, but with resonance, I think, for very much the debates that we're going through today. So we're going to, of course, continue talking in the sections, but any top-of-mind question, clarification, we would welcome now. And Ian, I'll let you take on one or two before we have to break.
This person is indicating that you should have a microphone.
Oh, if you don't mind coming to the mic, or Trevor, are you going to bring the mic?
Sorry, to start again. Basically, I really like I'm from the States, so I'm actually not used to the idea of articling. It's something that's been growing on me. And doing the reading and seeing how it's really transitioned from a practical setting to an educational setting is interesting on the one hand. On the other hand, I don't know when we made the jump from going to 2 years of 2 years of articling to 1 year of articling, because it seems like it's a really, really important part of practice.
Yeah, it's interesting, you say that, because I had that feeling when I myself graduated. I remember having done a PhD and then a law degree. I'd been in university for 13 years. And when I started to practice, I didn't know anything about the practical aspects. And articling was, I thought, exceptionally important in terms of helping ground you and give you that experience. But it's one of the constant debates. But as Cesar Wright said, I don't train lawyers for the first 6 months of their practice. I train them for their career. And so you're going to learn those practical things, whether you learn them in articling or as you start your practice. And you're going to probably make some mistakes and learn the hard way, as education experience is a tough teacher at times. But I agree, you need both. You need some of that practical training. I certainly am one that believes that we should retain articling. I think articling is a very important aspect. In my practice, I remember in my third or fourth year, I was down in New York working on a deal, and there was somebody who'd just been called to the bar in the States who had no practical training, and very smart person, but knew nothing about what to actually do. And I was, this is the person on the other side of the transaction. I was having to guide them through, saying, you should be doing this, you should be doing that, So I really do think that articling does serve a practical purpose.
Wait, well, maybe we'll do this, because looking at the time, I know we're going to have to break in a moment, but there's one question that's been nagging at me as I've been listening to Ian, and it's even more, I think, apparent in reading the excellent histories that, which are really just great stories, in addition to covering important material for us. But the question that's been nagging at me, and maybe I'll finish with this one, Ian, for you, is, are you telling the story of how change happens, how education and the practice open up, become more inclusive, become more progressive, become more aware of a public interest, less of just the private calculations? Or is it really the opposite, the story of the resilience of a very insular community against all the forces of change? And remember, in these years that we're talking about, 1889, Osgoode being dominated by the profession, there were certainly other parts of the country where law schools were governed by their law societies, but also Dalhousie, which had been university-based throughout this entire period. And you heard the reference to Sidney Smith. It's where Willis went off. So it's not like it was only an American idea or ideal. So is your story the story of reform and change? Is it the story of conservatism and resistance to change? And I think that also is a tension we're continuing to explore in the current debates, and you've followed the current debates as well as explored the history. So I'd be curious on your parting thought on that front.
Well, I mean, I think in a sense it's the story of both. I think it's the story of how changes happen and how you overcome reluctance and, you know, the conservatism of the profession. To my mind, you know, if you look at the two people, Caesar Wright and Sidney Smith, they're both become an important aspect of this, and we all focus our attention on Caesar, naturally. I mean, he attracted the attention, but Caesar was the sort of person who believed that the way to change people was to hit them over the head constantly with what he saw as the truth, the principles, on and on and on. And what he did was create a real backlash against him. Sidney Smith is the one who ended up engineering change, because Sidney Smith knew how to compromise. He knew how, he was the politician, he knew how to address people's concerns rather than say, oh, you must change, you have no choice. Saying, well, you know, there is some merit to what Caesar's saying, but we don't have to go the whole way. You know, we can do this, we can do that, we can, and he's the one who brought about change. And I think that's, to my mind, the hero of the story is really Sidney Smith. And there were others who came in as well to help him. But there's a wonderful letter that I came across when I was doing the study. It was somebody saying, the benchers have agreed to meet, but on only one condition, that Caesar Wright not attend the meeting. And Sidney Smith wrote on the bottom to his secretary, I want to be the one who tells Caesar this. It's got to be positioned in a way that he will accept. And that was the genius of Sidney Smith. He knew that Caesar wasn't going to be happy with this, but he said, I can get him to accept this. And he did. And they did eventually bring about change. So I think it's the story of how change happens.
Well, as someone who's had the experience of teaching in Sidney Smith Hall, I can confirm it is a sad testament to a great personality. The architecture could use the kind of sprucing up that this great law school has had, that U of T is getting, and the story of the relationship between the Toronto schools, legal education in Ontario, and the profession is one that we're grateful for Ian to get us started in discussing. We'll continue throughout this course, and I hope throughout this year of reflections on where we've come from and where we're heading on this, our 125th. So as we part now and have a break as we make our way to the sections, and you should have the rooms and the schedules, please join me one last time in thanking Ian Kyer.